Hello again, everyone. I hope the start of your week is going well, other than this lousy weather. I want to start off again by saying well done to everyone. I actually take notes while reading your posts in order to remind myself to respond to certain things, but almost every note that I take is addressed by one of you once I get further along in the readings. So well done. Thank you so much. You guys are doing fantastic. Like I said in the announcement from yesterday, I am collecting some articles to post regarding some of the information that you all have been discussing, and I intend to have those posted in the student lounge in the next few days. If there's anything else or anything in particular that you guys would like to have some more information about or would like to have an opportunity to read more about, please go ahead and let me know. You can shoot me a text or an email, whatever works best for you, and I'll include some information on that subject in the post. This week, your text covers correctional policy and offender rights. The foundations that support the legal rights of prisoners are found in constitutions, statutes, case law, and regulations. Constitutions describe the institutions of government and the list of basic rights of individuals. Statutes are laws that are created by elected representatives at all levels of government. Case law refers directly to judges' decisions in a specific case that either creates new law or modifies existing laws. And regulations are rules developed by government agencies intended to help guide officials' decisions. Looking back into the mid-1960s, the court abandoned its hands-off policies with prisons that had been the norm and recognized that prisoners could sue state officials for violating their constitutional rights. This led to the prisoners' rights movement, which actually used ideas and language similar to the civil rights movement, and resulted in more legal protections for inmates in correctional facilities and offenders on probation and parole. The constitutional rights of prisoners are mainly found in the First, Fourth, Eighth, and 14th Amendments to the Constitution. The First Amendment protects freedom of speech and expression, as well as the establishment of the free exercise of religion. The Fourth Amendment protects inmates from unreasonable search and seizures. The Eighth Amendment protects inmates from cruel and unusual punishment, and the 14th Amendment provides inmates due process in prison discipline and protection against racial discrimination. If you are interested in reading more about the prisoner rights movement from a social viewpoint, I highly suggest starting with the lead up to the Attica prison riot and moving forward from there. In 1972, the United States Supreme Court ruled that the way the death penalty was used constituted cruel and unusual punishment in Furman v. Georgia. The justices were concerned about the ambiguity of the wording in some state statutes and the lack of consistency in use of the death sentence. The decision that was made in Furman v. Georgia invalidated death penalty laws. However, shortly after the Furman decision, 35 states enacted new death penalty laws that provided some more careful decision-making following Georgia's lead. In 1976, under the Gregg decision, which was actually a part of a group of cases heard by the court regarding the death penalty in 5 southern states, it was decided that the states must have bifurcated or split hearings to determine guilt and a proper sentence. The court also decided in 1986 in Ford v. Wainwright that an insane person cannot be executed based on the Eighth Amendment protection against cruel and unusual punishment. Despite statistical evidence that suggested the possibility of racially discriminatory practices in the application of cases in Georgia, the court determined in 1986 via the McCleskey v. Kemp case that such evidence must be present in a particular case to have merit. In 2002, the court prohibited the execution of the mentally retarded through Atkins v. Georgia. And finally, in 2005, the court discontinued the execution of those who committed crimes when they were younger than 18 years of old. That case was the Roper v. Simmons case. So that's kind of a brief overview of the cases that have been kind of landmark cases in looking at offender rights. One last thing to touch on concerning prisoner rights would be grievances. Inmate grievance mechanisms are designed to help diffuse tensions within correctional facilities. Prison ombudsman programs use a public official to investigate inmates' complaints and recommend corrective measures. These complaints can be anything from broken bathroom fixtures, program availability, or about particular staff. Mediation can be used and is a consensual and voluntary process in which a third party assists disputants in resolving differences. And legal assistance mechanisms are also available to inmates to help guide them in legal matters. It's a short video this week. If you guys have any questions or concerns regarding any of the material, please let me know. And again, keep up the good work. Thanks.